want to spend a few moments today to discuss with you a case called United States versus Elonis, Elonis. It's a case that was decided based upon a criminal conviction in Philadelphia, in the Eastern District of Pennsylvania. He was convicted, the statute doesn't matter, but it's 18 U.S.C. 875, subsection C, I believe it is, for putting a threatening statement or making a threatening statement in interstate commerce or in an instrumentality of interstate commerce. And the facts that underlied the charge were that the man named Elonis had gotten into, and as you'll see, he's pretty disturbed mentally, but had a very strained relationship with his person who became his wife. As part of that, he acted out, but he worked at Dorney Park, recreational park outside of Philadelphia, and he posted several threatening posts on the internet. And I won't get into all of them with you. And I don't know if I should edit the language or not, but since you're all adults here, I'm inclined not to, and I'll just quote what he said from the opinion. And sometimes we edited out the F word, sometimes we didn't. But the first one he wrote in October of the year in question, he wrote on a Facebook page, part of it was, "I'm a nuclear bomb and Dorney Park just fucked with the timer. If I was the general manager, I'd be on the phone with Sandusky, which was the headquarters for the park, discussing a damage control plan, but I am not, and y'all haven't heard the last from Anthony Elonis." The park personnel became very concerned, as you can imagine. He posted another one after that because his wife and some of the employees actually had become terrified and swore they would never go back to Dorney Park. He then stated in part, "You all think it's too dark and foggy to secure your facility from a man as mad as me." He was charged for that post, threatening the park's employees. Ironically, or not ironically, but interestingly, he was later acquitted by the jury of that charge. However, he was convicted when it came to threats he posted aimed at his future wife and also various school children. One of the posts that he posted in October of 2010 was, and I'm quoting now, "There's one way to love you, but 1,000 ways to kill you. I'm not going to rest until your body is a mess." He then went on to say, "Guess it's not your fault. You're like your daddy. Raped you, so hurry up and die, bitch, so I can forgive you." Later on in November, he posted the following. And I should note he did this because there was an intervening decision with someone who was doing a rap song pertaining to the President of the United States. It was held that because the person in the song was only talking about theorizing assassinating the president, that was not illegal. In other words, the court had held that it's not illegal to say that you want to kill the president. He then tried to incorporate it into his Facebook post with the following: "Hi, I'm Tone Elonis. Did you know that it's illegal for me to say I want to kill my wife? It's one of the only sentences I'm allowed to say. Now, it was okay for me to say it right then because I was telling you that it's illegal for me to say that I want to kill my wife." This gets a little bit confused, but it was the way he spoke. "I really, really think someone out there should kill my wife, but not illegal for me to say with a mortar launcher." And then he gets into basically giving a formula for someone who might want to harm his wife. He says, "It's extremely illegal to go on Facebook and say something like the best place to fire a mortar launcher at her house would be from the cornfield behind it because of easy access to a getaway road, and you'd have a clear line of sight through the sunroom to the house." And he attached to that posting a diagram of the house, which was deemed to be very, very accurate. His wife became very frightened, understandably so, got a court to issue a protection from abuse order, which ordered him to stay away. He followed that up then, and he was at the proceeding when his wife obtained this protection from abuse order. He responded with the following post on Facebook: fold up your PFA, which is short for protection from abuse order. Fold up your PFA and put it in your pocket. Is it thick enough to stop a bullet? And then a few more words in that same quote. And then he said, it's not enough. I've got enough explosives to take care of the state police and the sheriff's department. Another post the next day, enough elementary schools in a 10-mile radius to initiate the most heinous school shooting ever imagined, and hell hath no fury like a crazy man in a kindergarten class. The only question is which one. That post became another count in the indictment. And then finally, one of his quotes a few days later, I'm a crazy sociopath. I'm going to be famous because I'm just an aspiring rapper who likes attention. He was charged with transmitting interstate commerce communications containing a threat in violation of the statute I mentioned earlier, 18 U.S.C. 875C. He argued at trial that his speech was protected by the First Amendment, and he claimed that he did not intend to make any threats that would ever be violently acted upon. He claimed these are only lyrics. They were for entertainment purposes only, and that they weren't intended for anyone to feel like they were being threatened, quoting from his defense. I did not want anyone to feel scared. He also added, I did not care what other people thought. At his trial, the court instructed the jury in part as follows. A statement is a true threat when a defendant intentionally makes a statement in a context under such circumstances wherein a reasonable person would foresee that the statement would be interpreted by those to whom the maker communicates the statement as a serious expression of an intention to inflict serious bodily injury. The government's closing argument to the jury emphasized that point, and the government argued in part, you should find him guilty, and it doesn't matter whether or not the defendant thought that anyone would feel threatened or had acted on the threat. The prosecutor said that the fact that the threat was put into interstate commerce would be enough to convict. The jury convicted him of all but the first one going to threatening the employees of the amusement park, and we affirmed it on appeal. Our decision was taken to the Supreme Court, and in 2015, the Supreme Court reversed us. And the court said that the federal criminal liability generally does not turn solely on the results of an act without considering the defendant's mental state. And that's very important. It's a concept called mens rea. It's the state of mind of the defendant. I'm not sure there are any criminal statutes which allow one to be convicted absent a finding of guilty knowledge or guilty mind or a certain intent defined in the statute. Such a statute would be what we call a strict liability statute. And for criminal law purposes, I don't know of any statute, as I just said, which imposes strict liability just based upon the results of one's actions without requiring a certain mental state when the person was committing the act. The Supreme Court therefore found that the jury instruction, which I just relayed to you, was erroneous. And the court explained that instead, the jury should have been instructed that it could convict Elonis if it found that he transmitted a communication for the purpose of issuing a threat or with the knowledge that the communication would be viewed as a threat. Now, you could argue that the kind of language which I've just given you is such that the person had to have intended to be issuing a threat and had to have knowledge that the person, he or his wife, would view that as a threat. But that's not sufficient. In the Supreme Court's eyes, the jury had to be told that that mental intent had to accompany the act. We affirmed the conviction on what's called remand, but the Supreme Court sent it back to us. And we concluded that the evidence in this case was so overwhelming that even though the jury instruction was erroneous, and the jury should have been informed that it can only convict Elonis if it found him to have one of two mental states, either that he had he issued the threat with the knowledge that the communication would be viewed as a threat, or with the intent of communicating a threat. The evidence was so overwhelming that there's no way the jury could conclude anything but that he had that mental intent when he issued the Facebook commands. There was a case much earlier in 1969, I believe, called Watts versus the United States, which came up with the doctrine of actual threats or imminent threat. And the court there said that the First Amendment protects any putative or reported threats unless it conveys an imminent threat or an imminent danger. And you may have heard the term clear and present danger. Watts is related to that, but it's a little bit different. It's a little bit broader, actually. What the court in our case said, and I'm quoting now, well, let me back up a second. The defendant contended that the government had to show that he acted with the knowledge that a reasonable person's interpretation of the speech would be threatening, or that a knowledge that a particular person would consider the communication threatening, not necessarily equivalent to knowledge of how a reasonable person would understand them. And that's where we found there was harmless error, because the evidence was so overwhelming that that would be regarded in such a context. Particularly in this day and age, the threat about school children and creating havoc and terror inside a school, and him saying the only issue is which one. And he said in his Facebook post that there were so many elementary schools nearby, that kind of speech would not be protected under the First Amendment. It is something which the courts now have to wrestle with in the context of Facebook posts. And we're seeing more and more, especially with the kind of language that we see in rap music, the kind of communication, if you can call it that some people might deem as vulgar or threatening. And the issue then becomes, to what extent does the First Amendment guarantee of free speech immunize that kind of speech from criminal prosecution? Elonis would suggest or say that if the person who is the speaker uses an instrumentality of commerce, which Facebook certainly would be, the internet, and makes a threat with the knowledge that a person hearing that speech would perceive it as a threat, that would be sufficient to remove First Amendment protection. And I think it's a nice balance. And frankly, when I first read the Supreme Court's decision reversing our earlier decision, I just scratched my head and I thought that I couldn't make much sense out of what the Supreme Court had said, because our case had such strong facts and it was so clear that the defendant there intended to threaten his wife. She felt stalked, actually. What the Supreme Court held legally, to my mind, just seemed pretty illogical. But the more I thought about it, the more sense it makes. The First Amendment really does not allow for a situation where anyone in the public who might hear something would deem that as threatening, would then yield criminal liability on the part of the speaker. There's so much offensive language out there. But even before this, I'm going back to the 60s now, and some of you may remember, there was a song which I just absolutely love called the Bad Man's Blunder, I think it was called, by the Kingston Trio. And he talks about waking up one morning and not feeling very good, so he went out and he shot the deputy down. And next morning, he thought it was time to make a getaway. The whole song is about him killing a deputy because he had a bad day, basically. And recently, and I wish I could remember where this was because I will refer you to it, I heard a presentation, I think on YouTube, where someone took the lyrics of the Kingston Trio that was a popular song. In fact, it was the top 10 song for weeks, if not months, during the 60s. They put that to the beat of rap music, and it took an entirely different connotation and meaning, became more threatening. And you can argue that it became more threatening only because of the cultural translation from a folk song lyric in the hands of the Kingston Trio to a more, quote, threatening rap beat. But the words are the same and the message is the same. Clearly, somebody hearing that lyric could feel threatened, but that should not be enough because some member of the general public felt threatened to impose criminal liability on the part of the performer. It has to be that the performer, in that case, the Kingston Trio, intended someone hearing the song to feel threatened, or with the knowledge that someone hearing the song would feel threatened. I mean, arguably, the Kingston Trio, when they wrote that song, had absolutely no belief that anyone hearing the song would think it was anything other than a quote, cute little song about somebody who shot a deputy sheriff and ended up getting life imprisonment. So I think particularly in this day and age with the internet and how easy it is to get an audience of hundreds of thousands, if not millions, that test that was formulated in Elonis is a way of protecting something which might have artistic value from something which only really serves as a threat. It also works a little bit differently in the context of hate speech. And we haven't had a case yet from the Supreme Court where that concept has been specifically applied in the context of an internet posting that might be deemed hate speech and therefore not protected by the First Amendment. Hate speech would be protected unless it gets into this imminent threat area that I mentioned earlier. And drawing that line and balancing that out is incredibly difficult. It's one of the most difficult things that we as judges have to do because we don't want to restrict the First Amendment. By the same token, we don't want the instrumentalities of commerce now, especially since they are so incredibly powerful and reach such a broad audience. We don't want to give license to someone to use those instrumentalities to threaten people, to put language into the stream of commerce, which serves really no purpose other than to formulate hate. And it may well be that what I just said, the purpose formulating hate, it may well be that the court would take the test growing out of Elonis, the intent of the speaker, and apply that in the hate speech so that if it could be shown that the purpose of the speaker was to formulate hate, or the speaker was aware that the result of the message was to promulgate hate, that may be enough under the Elonis test to take hate speech out of the confines of the First Amendment. But that is the protections of the First Amendment. That's the subject for another course, and it could easily require several hours of discussion. It would be a very fascinating discussion, but I think it's beyond the purview of our presentation here today. Thanks very much.